Hi, I'm Kelsey Reichman, a reporter covering the Supreme Court, and we're just days away from a new Supreme Court term, and it's going to be a doozy. Let's get into it. September 29th marked the 20th year of the Roberts Court, and since we are in a Taylor Swift week, as I like to think of all album release weeks, the court is often defined by the Chief Justice who sits atop it. So September 29th was the 20th anniversary of Chief Justice John Roberts being sworn in, and therefore the 20th year of the Roberts Court. As we look back at Roberts's confirmation hearings, a lot of legal experts point to his famous quote about calling balls and strikes and not pitching or batting. And this was supposed to be a reference to judicial humility. But as legal experts look at what the Roberts Court has done over the last 20 years, they say that this is the most activist court in American history. The Roberts Court has been no friend to the Voting Rights Act, and that will continue in the 2025 term. One of the major cases of the 2025 term asks whether enforcing the Voting Rights Act is inherently unconstitutional. The Roberts Court has really narrowed the Voting Rights Act over the last 2 decades, and Section 2 is one of those remaining sections that is usable and gets used quite often in redistricting efforts. The case at the center of the Supreme Court appeal this time was actually a case from last term. It's a holdover where the justices said, we're not going to decide this case because we want to add an extra question. They're hearing re-argument, as it's called, and this tends to happen only in very big cases. Some other big cases that got re-argument include Brown v. Board, Roe v. Wade, and Citizens United. So when Congress created the Voting Rights Act, it drew on the Reconstruction Amendments, the 14th Amendment that granted all citizens the right to vote, and the 15th Amendment that prohibited the denial of voting rights to anyone based on race, color, or previous servitude. Section 2 of the Voting Rights Act really aims to enforce the 15th Amendment. So it says that you can't redistrict in a way that would dilute minority voters. In Louisiana, this related to adding a second majority Black district. The Supreme Court was deciding whether that second majority Black district complied with Section 2 of the Voting Rights Act. Now the justices are asking, well, is it even constitutional to say that there needs to be 2 majority Black districts? And this goes in line with the Roberts Court and what they did on affirmative action, and saying that looking at race, considering race, is inherently discriminatory. And it goes with this colorblind approach to the Constitution that justices like Justice Clarence Thomas have adopted. So in this case, we could really see the Supreme Court basically nullify the Voting Rights Act, which would be a huge deal, not only in the fact that the Voting Rights Act is seen as this crowning achievement of the civil rights movement, but also in terms of what Congress can do with its authority. The 15th Amendment kind of explicitly gave Congress that authority to prohibit discriminatory voting. And by removing that power under the Voting Rights Act, if the court were to say that Congress took too big of an action here, that Congress was not allowed to act in this way, it would really limit how Congress can create a multiracial democracy in the United States. So if the Supreme Court finds that Section 2 of the Voting Rights Act violates the 14th or 15th Amendments, that could not only mean that Louisiana would lose that second Black district, but they would also probably lose the first Black district, because that was also created in line with Section 2 of the Voting Rights Act. And that would kind of ripple across the country. Some legal experts even estimate that 20 to 25% of districts could be overturned if the Supreme Court were to rule in this way. But the Supreme Court is also considering a really important campaign finance case. This case was actually originally brought by Vice President J.D. Vance when he was a Senate candidate. Now it is led by the National Republican Senatorial Committee. The appeal seeks to change federal limits on campaign expenditures, coordinated campaign expenditures between political parties and candidates. Currently, there is a federal law that was created after Watergate to prevent quid pro quo corruption. That limits how parties and candidates can coordinate and spend money. However, the Republican Party is saying that that violates the First Amendment. Now, if you are aware of Citizens United, which was this huge ruling that said that corporations have a First Amendment right to unlimited spending in elections, this is similar. The case challenges that federal law based on the First Amendment. Legal experts say that between these two cases, you could really see the Supreme Court end some very important electoral protections while also supercharging money in politics. I've talked previously about how the Roberts Court is ruling on the shadow docket in favor of Donald Trump. Well, the merits docket is also going to have some big rulings on executive power. One of those comes directly from the shadow docket. This is Trump v. Slaughter. If you'll remember, this was the FTC ruling that the Supreme Court issued on the emergency docket. They said that Trump could fire the FTC commissioner, even though Humphrey's executor the United States. That 90-year ruling still is on the books. Well, they are going to consider in December whether to overrule Humphreys. And doing so would really complete this decades-long project that the Roberts Court has been on for the last 2 decades. They've really chipped away at Humphreys, and now they could completely overturn Humphreys. And while that is a huge deal, and it will be a big deal if they overrule Humphreys, it seems dwarfed a little bit by the fact that they're allowing Trump to basically act as if Humphreys is already overruled. Trump v. Slaughter will be heard in December, but in November, the Supreme Court is hearing an extremely expedited case about Trump's reciprocal tariffs. Tariff authority typically falls under Congress's purview, but the Supreme Court is going to see whether Trump can use that emergency provision in IEEPA to basically unilaterally levy tariffs worldwide, as he has been doing. And so that case will be heard in the first week of November, and we could see a ruling on that by the end of the year, which would be extremely expedited. The Supreme Court only took up this case a few weeks ago. They are hearing this expedited appeal based on the Trump administration and the businesses who are challenging the Trump administration's actions, based on their claims that the Supreme Court really needs to resolve this issue now, so that we have some answers on how global trade will function. When we're thinking about the Roberts Court and LGBTQ rights, it is important to mention that the Roberts Court was the court to issue Obergefell v. Hodges, legalizing gay marriage in this country. However, since that ruling, the Supreme Court has, I guess you could say, soured on LGBTQ rights, and in particular transgender rights. One way they're really doing this is through the First Amendment. If you remember, a few terms ago, the court heard a case known as 303 Creative, and that case related to a Colorado website designer who did not want to make a wedding website for a gay couple. And so the Supreme Court kind of created this carve-out in anti-discrimination law and said that she had a right to her free speech, and allowed her to not serve gay couples. The Supreme Court is taking up another appeal in the same vein, but related to regulation on professional conduct. This case involves a counselor who's challenging Colorado's prohibition on conversion therapy. And she says that the prohibition harms her free speech rights. When we're thinking about the First Amendment in this way, it's important to think about what is being regulated here. So Colorado says that what they're regulating is conduct. This is professional conduct. While counselors use their speech for treatment, they're inherently using their conduct. So if we think about the legal profession or the medical profession, there are a lot of things that states can regulate and the federal government regulates according to conduct. Colorado says this is the same thing. Of course, this counselor disagrees and says that her free speech rights are being harmed. And while this is a First Amendment case, it also has that undertone of transgender rights. And if we remember last term, the Supreme Court issued a big ruling finding that Tennessee could ban transgender teens from getting gender-affirming care, even though that other teens could receive the same exact medical care, but to reaffirm their sex at birth. The Supreme Court is also going to continue their review of transgender rights directly. They are reviewing a case from West Virginia that asks whether the state can ban transgender girls from girls' sports. Now, the term officially starts on October 6th, which is the first Monday in October when every new Supreme Court term starts. I'll be covering all these cases and many more as the Supreme Court goes through another massive term. Stay tuned.